4, 3, 2, 1.
The Honorable Court of Appeals of Tennessee is now in session.
Excuse me. Good afternoon, counsel. Before we start, we don't anticipate any technology problems, but if we should have any, everybody just take a deep breath and we'll pause, and our computer experts will get it all straightened back out and get us back online. So call the case, Mr. Hibner.
Loring Justice versus Faye Michael Nordquist, PH.D.
We'll hear from the appellant.
Good afternoon, and may it please the court. Lynn Guerrero for the appellant. I would like to reserve 5 minutes for rebuttal, please.
That'll be fine.
Thank you. This case is about deception and the mistreatment of a family by the appellee, Dr. Nordquist. On May 22nd, 2013, Dr. Nordquist called the appellant, Mr. Justice, and undisputedly lied to him. He solicited information from Mr. Justice and informed about his son, N, and their blended family, posing as only a treater for N. Dr. Nordquist lied to Mr. Justice and informed he did not know why he was seeing N or why N's mother had brought him. The truth is that Dr. Nordquist knew exactly why he was seeing N. N's mother and her attorneys had hired Dr. Nordquist as an expert witness in a case directly adverse to Mr. Justice. By the time Dr. Nordquist called, Dr. Nordquist had agreed to assist N's mother in a scheme to limit N and Mr. Justice's contact as much as possible. In the phone call, Dr. Nordquist provided clinical recommendations to Mr. Justice, and Dr. Nordquist even invited Mr. Justice to come and speak to him about N and the blended family. Mr. Justice accepted, but he never heard from Dr. Nordquist again, and now we all know why. It was not until months later that Mr. Justice found out Dr. Nordquist was working directly adverse to him when Dr. Nordquist authored an affidavit making so-called emergency recommendations consistent with the plan to limit N's contact with Mr. Justice as much as possible. Now, this kind of behavior not only falls well below the standard of care for psychologists, but is also unconscionable and cannot be tolerated by these courts. Dr. Nordquist moved to dismiss, asserting the statute of limitations had expired. There was insufficient proof of a provider-patient relationship. Mr. Justice lacked standing to sue on his minor child's behalf, and that the basic gravamen of the complaint was Mr. Justice's dissatisfaction with Dr. Nordquist's testimony in the underlying case. The trial court granted the motion to dismiss on these grounds. However, all of the grounds in which the trial court dismissed the complaint were matters outside the pleadings that should not have been considered in deciding whether to grant the motion. Appellee's motion to dismiss attached and discussed approximately 193 pages of exhibits, none of which were attached to the complaint. Rule 12.02 of our rules.
Counsel, what were the exhibits, just category-wise?
Yeah, sure. The exhibits were non-final orders of other courts in other cases, 2 other cases to be exact, notice letters in a previously non-suited case. There were a few other things, but those were the 2 big categories of what were attached to the motion to dismiss. Now, Rule 12.02 of our Rules of Civil Procedure requires the trial court to convert motions to dismiss for failure to state a claim to motions for summary judgment if matters are presented outside the pleadings. Alternatively, the rule requires the trial court to exclude the materials that's presented outside the pleadings. This gives the parties adequate opportunity to respond under the safeguards of Rule 56. Here, the trial court neither excluded the material Dr. Nordquist presented outside the pleadings, nor converted the motion to a motion for summary judgment in violation of Rule 12.02. Now, Dr. Nordquist never filed an answer. Before the trial court's dismissal of the original complaint became final, Mr. Justice filed his first amended complaint as of right under Rule 15, and this amended complaint was never dismissed. because of the award of fees and costs in the case and the trial court's refusal to engage the amended complaint, among a couple of other things, the appellants appealed here in an abundance of caution. It is the appellant's position, however, that this appeal is premature in large part, except for perhaps the award of fees and costs, given the pending amended complaint. But now, moving back to the motion to dismiss and the grant of that motion to dismiss.
Oh, counsel, let me ask you to address that some little bit more about why you say, the filing of the amended complaint after the entry of order of dismissal was appropriate and keeps the lawsuit alive.
Sure, it keeps the lawsuit alive because the appellant or the plaintiff here in the trial court had the right under Rule 15 to amend one time before a responsive pleading was filed. Dr. Nordquist, like I said, never filed an answer. Now, that's this is cited in my opening brief. That's the McBurney versus Aldrich case that comes out of that case. That's the holding of that case, that even after dismissal, if the defendant has not filed a responsive pleading, the plaintiff may, as of right under Rule 15, file an amendment.
In that case,
Dismissal.
I'm sorry, go ahead. Judge
Yeah,
Martin.
after dismissal, the plaintiff still have a right to file to amend.
Yes, and that's the holdings of McBurney versus Aldrich. And there's a couple of other ones that are escaping me right now, but they are all cited in appellant's brief.
Okay.
In those cases, was an order actually entered granting the motion to dismiss before the amended complaint was filed?
The holding it was that after the dismissal. Now, I don't know if that was after the hearing and the court said, yeah, I'm going to dismiss this, or if it was after the order was after an order was entered. I'm not actually sure of that. However, the holding is after dismissal, you still have the right under Rule 15 to amend the complaint if the no responsive pleading has been filed. Now, the statute of limitations is an affirmative defense on which the appellee had the burden of proof under Rule 8.03, and the statute of limitations is a question of fact. Instead of converting the motion under Rule 12.02 as required, however, the trial court allowed counsel for Dr. Nordquist to unilaterally assert in a motion to dismiss without even a citation when appellant's statute of limitations expired, and then the trial court granted the motion on those grounds. The appellant never had a chance to reasonably respond given the failure to convert under 12.02, and this was reversible error. On the ground of dismissal where without any citation, the trial court ruled that the telephone call between appellant and Dr. Nordquist was not, quote, as a matter of law, enough to establish a patient-physician relationship, close quote. Well, this is clearly a question of fact, for one, but we see patient-provider relationships established on less than this all the time. When someone is having chest pains, for example, and calls the emergency room, and the doctor tells them not to come in, but then in turn, it turns out that they were having a heart attack, that communication, no matter how short, absolutely creates a provider-patient relationship. Again, this is a question of fact, and Mr. Justice did not have a legitimate opportunity to respond under Rule 56 as he should have, given the trial court failed to convert the motion under Rule 12.02. Here, the original complaint alleges Dr. Nordquist called Mr. Justice, not the other way around, and made affirmative steps to diagnose and treat the family and establish treatment of the family that included Mr. Justice.
Ms.
Now,
Guerrero, let me ask you a question. I'm interested in the timing of these orders. The motion to dismiss was entered on February the 28th of 2020, and the amended complaint, the first amended complaint that was filed was June the 8th of 2020. So was the motion I think you filed a motion to alter or amend, which was denied. I think on May the 7th. And then on June the 8th, this first amended complaint was filed. Why wasn't that order final?
Why wasn't the order denying the motion to alter and amend final?
No. Why wasn't the motion to dismiss a final order?
Well, one, the motion to dismiss wasn't a final order because the amended complaint was filed within the time before the order denying the motion to alter and amend was filed, or was final, would have been deemed final 30 days.
Well, the order denying the motion to alter or amend was entered on May the 7th.
That's the computation of time under the rules of appellate procedure and the rules of civil procedure. It was the next Monday. The time for expiration fell on a Saturday, I think, or a Sunday. It fell on a weekend day. So then that would mean that next Monday would count within your time to either file a notice of appeal or file your amended complaint, whatever the strategy was at that point.
So you're saying that was either the 30th or you're saying that the June the 8th was the 30th day?
Yes.
All right, go ahead.
All right.
Thank you.
Counsel, use your time. You have your time for rebuttal. We'll hear from the appellee. Ms. Morton, I'm sorry, you're still muted.
Sorry, Your Honor.
That's okay.
I'm Kathy Morton. I'm a member of the Blount County Bar, and I represent Dr. Nordquist in the case. This is not a case about deception or treatment of the family. This is a case of abuse of the judicial system and of Dr. Nordquist, and continued abuse of both our courts and Dr. Nordquist. It's an attempt to relitigate the issues of Dr. Nordquist's credibility in the underlying custody and paternity case, which has already been determined by Judge Ash in his order in April 2017 and affirmed by this court in the Court of Appeals. As noted by Judge Ash, this man, Loring Justice, has a pattern of manipulation, over controlling and bullying people. And that includes not only Dr. Nordquist, but the other experts that testified in the underlying case, Miss Nelson, his wife who sued him in that case, her lawyers, and continues to this day in this court. That's the first thing, but you don't even have to get to the merits of this case. This case was not timely filed, this appeal. The appeal became final 30 days after entry of the order on the denying Mr. Justice's motion to amend and alter the February 28th order of dismissal. That order was entered on May the 7th. The time for filing would have been June 6th, which was a Saturday. So under the rules, Mr. Justice would have had until the following Monday to file one of the four motions under Rule 59 of the Rules of Procedure. And that's Rule 50.02 of judgment in accordance with a directed verdict, under Rule 52.02 to amend or make additional findings, under Rule 59.07 for a new trial, or 59.04 to alter or amend the judgment. There is no rule that says that the filing of an amended complaint would ever extend the time or toll the time for filing a notice of appeal. And the defendant, without any authority, cites in his reply brief to this court that the filing of the amended complaint erased the order of dismissal. There is no such rule in our courts. So the first issue, without getting into the merits, is was the case or the appeal timely filed? And we take the position that it was not.
What do you say, Ms. Morton, about the cases that opposing counsel talked about that allowed an amended complaint to be filed after an order of dismissal was entered?
I think that counsel was incorrect in informing the court that was not the facts of the case. The facts was that the amended complaint was filed after the motions to dismiss, but not before an order or a ruling on the motions, where they went back and clarified their complaint, apparently based on allegations in the motion to dismiss.
So in those cases, the amended complaint was filed before the court even orally ruled on the motion to dismiss?
That's correct, as I recall those cases.
Okay. What about Justice versus Nelson?
I'm sorry, Justice versus Nelson, Your Honor, I don't catch the question.
Yeah, I think in that one it involved this similar situation. I'm not sure that issue was raised as to whether or not they could file an amended complaint, but I think that was the fact situation that was there when it came up to us after the entry of an order.
Okay. Well, okay, aside from that, if you get to the merits of the case, the trial court correctly found that the case failed to state a claim for which relief could be granted. First of all, Dr. Nordquist is immune from statements made during the judicial proceedings in the underlying case. As you can see from the brief, the gravamen of the complaint, as Judge Davis found, is based on the inconsistency of Dr. Nordquist's testimony. Page 12, 13, 14, 15 through 20 talk about how he testified inconsistently. So the gravamen of the complaint is, in fact, as Judge Davis found, Mr. Justice's dissatisfaction with the underlying testimony, for which he is immune, which is clear in our law and has been our law for many years. And I've cited those cases, and the earliest case that I've cited was 1962 up to the 89 case and 2000 case, first of Wilson versus Riccardi, 1989, and Jamoni, don't know if I pronounced that correct, versus McMillan in 2006. I don't know if the court would want me to go through the statements that he complains about in his brief, but he writes on page 12, or his lawyer writes, he testified inconsistently about his roles. He wholly page 13, contradicted himself. He argued on page 14 for something different than what he had said in a report to the court. He deceived the appellant. His conclusion and comments were unethical, and on and on and on, complaining about Dr. Nordquist's testimony in the underlying case. The trial court also found that the complaint did not state a claim for relief because one phone call on in May 2014 was insufficient to establish a patient relationship. And in fact, the phone call, according to the brief, was on page 13 of the brief that Dr. Nordquist informed Mr. Justice he had agreed to see the child a few times and determine if he could get him to a therapist, and that maybe the family should see someone like Dr. Tom Hanaway. There was no effort or undertaking to diagnose or treat Mr. Justice for anything. Judge Davis was absolutely correct in finding that on the face of the complaint did not establish a a patient relationship between Dr. Nordquist and Mr. Justice. It also is established on the face of the complaint and the court orders attached to the motion to dismiss. What was attached to the motion to dismiss were orders of the underlying court in Roane County. The court and the orders are all the pleadings and docket sheet in the original malpractice case filed in Blount County in December 2014. And the case in the Chancery Court and the Tennessee Supreme Court or the appeals court disbarring Mr. Justice. Those were matters that were correctly taken under advisement. Judge Dave Davis under rules 201 of the rules of evidence to take judicial notice. It was requested in the motion to dismiss that she take judicial notice of those documents. There was no response. The defendant had adequate time to reply. He had time from June of 2019 until February 14th, 2020 to respond. He didn't even show up for the hearing. He sent a court reporter, but he didn't even show up, didn't care enough to show up and argue the case. He had more than reasonable and adequate opportunity to respond to the motions in this case. With respect to whether or not this needed to be converted to a motion for summary judgment, they certainly had the opportunity to ask the court to do that. They knew the court had been asked to take these orders of the court, which are easily ascertainable as to their trustworthiness per judicial notice.
Counsel, excuse me, did they object at any time to the trial court considering those orders and other items that you had sent from the court?
Not until their motion to alter or amend, as I recall, Your Honor.
Okay. All right.
Okay. The other issue, which is on the face of the complaint, is the statute of limitations issue. The phone call was in May 2014. The original malpractice case was filed on December 29, 2014 in Blount County. A notice letter, the pre-suit notice letter required under the Tennessee Healthcare Liability Act 2926-121 was sent in August of 2014, advising Dr. Nordquist of the potential actions arising out of his care and treatment of the minor child. It does not say a thing about arising out of any care and treatment to Mr. Justice. So the statute of limitations as to Mr. Justice expired I think in May of 2015, but even in under him, it was August 2015, and no pre-suit notice letter had been sent to him advising Dr. Nordquist of his individual claim. As to the child's claim, Mr. Justice did not have standing to sign an authorization, the HIPAA authorization required under to go with the pre-suit notice letter, because paternity had not been established. The paternity was established when the order was entered in the Roane County Juvenile Court on April 18th, 2017. For 3 years after the HIPAA release was signed by Mr. Justice, and after the initial complaint in the Blount County case was filed. I'm sorry, I've lost my train of thought. There is a case on point, Milton versus Harness, which says that there is no legal parent relationship until the trial court orders such. So it's our position that Mr. Justice did not have authority to sign a HIPAA release on behalf of the child or notify Dr. Nordquist of a potential malpractice action. Moreover, in the proceedings in the juvenile court, there was a parenting plan entered, which gave mama sole decision making rights as to major decisions. I've asked the trial court, and I think the Court of Appeals allowed the trial court to supplement the record and send that parenting plan up to the court to review. And if you review under the decision making section of the parenting plan, you'll find that mama is the sole decision maker. She did not file this suit. She gave no authority to file this suit. And in fact, it's our position that counsel here today is unauthorized to represent this child in any capacity. That she, in fact, is violating her professional obligations in failing to comply with the rules of professional conduct. We ask this court to dismiss this case as frivolous and to award Dr. Nordquist his cost, damages, and attorney fees today.
Anything further, counsel? Ms. Morton?
No, sir, thank you.
Thank you. We'll hear from the appellant in rebuttal.
Thank you. Appellee's recitation of facts to try to prejudice the court are not only untrue in many respects, but also not in the record and the pleadings. But really, this is exactly why summary judgment proceedings were required below, and the trial court committed reversible error by violating Rule 12.02. Respectfully, the trial court took appellee's unilateral assertions as true and assumed the untruth of appellant's allegations in the original complaint without affording the appellant a legitimate opportunity to respond with the safeguards of Rule 56.
Counsel, excuse me, were any objections made on your client's behalf about the documents that were furnished to the court?
Yes, the appellant did ask the court to convert the motion to dismiss to a motion for summary judgment in his response to the motion to dismiss, although he didn't have to because it was required that the trial court do that anyway under Rule 12.02. Appellant also objected to the trial court's consideration of the exhibits in his response to the motion to dismiss, citing Rule of Evidence 201, on judicial notice, asked for a hearing if the court was going to take judicial notice of these documents that are outside the pleadings, and that is part of the record in appellant's written response to the motion to dismiss. Now, Dr. Nordquist misinterprets Mr. Justice's argument regarding the filing of the amended complaint. The filing of the amended complaint in this case is not a mechanism to toll the time to file a notice of appeal. The filing of the amended complaint as a matter of right under Rule 15 erased the trial court's dismissal of the original complaint, given Dr. Nordquist never filed an answer. And in that case, the filing of the amended complaint makes this, in large part, this appeal premature. And the case that stated
Counsel,
that held.
Counsel,
Oh, I'm sorry.
I don't understand you say it erased the order and I haven't compared the original complaint and the amended complaint. To the extent the amended complaint contained what was in the original complaint, and I understand it probably had additional stuff, I don't think that would erase the trial court's order as to that part, would it?
Well, I think it would, just given the additional context that the amended complaint puts on the original complaint. So actually, I think it would. And either way, the trial court dismissed in error. All of the grounds for dismissal that the trial court cited in its order of dismissal were inappropriate given the failure to convert under 12.02. The case that I cited
So
in
it's your position that the trial court still has jurisdiction on this case, and this case is the appeal is premature.
Yes, although I do perhaps think that this appeal is not premature as to the granting of the fees and costs that the trial court granted the appellee. Now, the trial court improperly imposed fees and costs under Tennessee Code Annotated 20-12-119. The trial court granted fees and costs before the time for appeal had expired, given the filing of the amended complaint and the appellant's position of that, or on that. Second, after I was disqualified as counsel in the trial court, which the appellant has raised as error in this court. By definition, the appellant was a pro se litigant. The statute prohibits assessing fees and costs against a pro se litigant in these circumstances. Third, the appellant also requested a hearing on appellee's motion for fees and costs twice of the trial court, but the trial court denied him an opportunity to be heard in derogation of due process. The case that I was thinking of that is cited in appellant's brief regarding the appellant's right, or a plaintiff's right, to amend a complaint even after dismissal is Freeman Industries LLC versus Eastman Chemical Company et al. It's a decision of this court from 2006, and that's cited in the appellant's brief. This is a case about Dr. Nordquist's deceptive practices to Mr. Justice, his patient, and his unethical mixture of roles while treating N that fell well below the standard of care. And even if this case were just about sour grapes, essentially, as appellee asserts, Dr. Nordquist was required to prove that at trial or by moving for summary judgment. The trial court had no authority to infer that on a 12.06 motion to dismiss. The appellant respectfully requests that this court remand the case for further proceedings. Thank you.
Thanks to counsel for both sides. We appreciate your briefs and your oral argument here. I think we understand the positions. Mr. Hibner, if you would please recess court till our next scheduled case.
This honorable court is now in recess until 3:30 p.m.